For $195 in about 72 hours, a stranger can order a report that lists every piece of real estate you own in all 50 states, every vehicle, every boat, every business filing with your name attached to it, every lien, every judgment, and every lawsuit you have ever been part of. No court order, no subpoena, no warning to you. That report sits one click away from millions of Americans who have no idea it exists. And the person most likely to order it isn't a criminal. It's an attorney in a quiet office running a number. Here's the number. Every plaintiff's lawyer in America works the same equation, whether they write it on a whiteboard or not. Take the top value of the claim, multiply it by the odds of proving it. Subtract the cost of getting there, the depositions, the experts, the 3 years of your life, and then multiply the whole thing by one final factor most people have never heard of, the percentage chance of actually collecting $1 after the verdict. That last multiplier is the entire ballgame. A $1 million claim against someone with nothing collectible is worth almost nothing. The same claim against a visible, cataloged, obviously wealthy defendant is worth chasing for years. He isn't guessing at your character. He's estimating your recoverability, and he does it before he ever files. Understand the pressure sitting behind that estimate right now. The costs and compensation running through the American tort system reached $529 billion, more than $4,200 per household, growing 7% a year, on pace to approach $1 trillion by 2030. Verdicts of $10 million or more hit a record 135 in a single year, totaling $31.3 billion, a 52% jump. And outside, investors poured roughly $19 billion into funding other people's lawsuits. Funded cases run more than 9 times longer and cost 360% more to defend. That's the machine deciding whether you look worth the trouble. So let's talk about what that machine can see. An asset search pulls deeds and recorded mortgages in every county in the country, titled vehicles, boats, aircraft, business entity records, every company where you appear as an officer, director, manager, or registered agent, uniform commercial code filings, tax liens, judgment liens, bankruptcies, your entire civil litigation history. Investigators cross-reference all of it against credit header data, known associates, and your own social media. Now the half nobody tells you. That same report cannot see your bank balance. It cannot see your retirement account. It cannot see your brokerage account or your tax return. None of that is public record. Reaching it requires a judgment first, then a court order and supplemental proceedings, a process that lands years after the complaint, which leaves an uncomfortable question. If the visible column is the only thing inviting the lawsuit, can you legally empty it? Before we get to structures, understand what actually stops most claims, because it isn't a trust, it's insurance. A personal umbrella policy averages roughly $300 to $400 a year for $1 million of coverage, and that's your first and best line. The layer that hires the lawyer, pays the defense, and makes the case settle inside the policy instead of coming for you. About 13% of personal liability claims exceed $500,000, and 7% exceed $1 million. Yet an estimated 1 in 5 people with real wealth carry no umbrella at all. Every structure in this video is worthless if the first layer is missing, because the plaintiff's lawyer who can't collect from an insurer will absolutely come looking for you personally. Now the structures. Title and benefit are two different things, and they always have been. A grant or trust. The same basic instrument as the living trust your parents probably had can hold legal title to your house while you keep every ounce of the use, the enjoyment, the mortgage deduction, and the capital gains exclusion when you sell. On the public record, the trustee's name appears. Yours doesn't, and federal law protects the move. Under the Garn-St-Germain Depository Institutions Act, a lender may not accelerate your mortgage when a residential property transfers into an inter vivos trust where you remain a beneficiary and your occupancy doesn't change. That's not a loophole. That's Congress writing you a permission slip in 1982. There's a second tool most married couples own and never use: tenancy by the entirety. Roughly 25 states and the District of Columbia recognize it, and it treats a married couple as a single legal owner rather than 2 people holding shares. A creditor with a judgment against only one spouse can't lien it, can't seize it, can't force a sale, because there's no separate half to take. Most states limit it to real estate. Florida extends it to bank accounts, brokerage accounts, vehicles, and business interests. And a state Supreme Court decision in December of 2025 made it easier than ever to establish on financial accounts. But know the ceiling. It does nothing against a joint debt. And the Supreme Court held in 2002 that a federal tax lien attaches anyway in every state, no matter how strong the protection. Then there's the entity layer, and this is where the internet gets loud. Wyoming Statute 1729-503 makes the charging order the exclusive remedy for a judgment creditor pursuing a member's interest. No foreclosure on your membership. No court-ordered accounting. No receiver stepping into management. The creditor receives a lien on distributions that may never be made, and Wyoming extends that protection even to single-member companies, which almost no other state does. The state doesn't publish member names either. On paper, it's the strongest statute in the country. So watch what happened to a man who relied on that theory. In Florida, federal regulators won a judgment against an operator of a deceptive advance fee credit card scheme. He held his wealth in single-member limited liability companies, and he argued exactly what the formation websites tell you, that a charging order was the only remedy available. The Florida Supreme Court disagreed. It held the creditor could compel him to surrender his entire membership interest outright, which is foreclosure by another name. The legislature didn't reverse the decision. It ratified it, writing the foreclosure path directly into the statute for single-member companies. One case, and the most popular structure in America, stopped working in one of its biggest states. Which brings us to the thing nobody selling you a $200 company will say out loud. Creditor enforcement is governed by the law of the state where the lawsuit is filed, not the state where you filed formation paperwork. In March of 2026, a federal court confirmed it directly. When a California court evaluates creditor rights against California real property, it applies California law, regardless of where the holding entity was registered. California courts have allowed reverse veil piercing when an owner treated the company as a personal checking account. New York creditors can obtain turnover orders compelling assignment of the interest itself. One national asset protection attorney puts it in 5 words worth memorizing. Privacy is camouflage, not armor. The anonymity story moved too, and it moved fast. In 2024, most American companies were required to report their beneficial owners to the federal government. Names, birth dates, addresses, identification documents. In March of 2025, an interim rule removed that requirement for every entity formed in the United States. A government accountability report in May of 2026 found the exemption eliminated more than 99% of the companies previously covered and warned about the illicit finance risk that follows. A final rule is still pending. States are writing their own disclosure laws to fill the gap. Anyone selling you permanent anonymity is selling you a photograph of a moving train, which is why the strongest protections aren't clever at all. They're the ones the legislature already handed you, and most people never claim. Congress made qualified retirement plans exempt from creditors. Texas and Florida protect unlimited homestead equity outside of bankruptcy. Inside bankruptcy, equity acquired in roughly the 40 months before filing gets capped at $214,000. Maxing out your retirement contribution is asset protection. It requires no trust, no entity, no attorney, and no fee. Now the part that matters more than every structure combined: timing. Nearly every state has adopted the Uniform Voidable Transactions Act, which lets a creditor unwind a transfer made to hinder, delay, or defraud them. The window is 4 years from the transfer, plus 1 year from when the creditor discovers it. After that, the transfer stands regardless of what you were originally thinking. Courts look for what they call badges of fraud: moving assets to a relative, keeping control after the transfer, moving nearly everything at once, doing it right after a threat arrives, concealing it. Someone who builds a structure while financially healthy, funds it partially, keeps enough on hand to pay current obligations, and reports it honestly on their tax return triggers none of them. Someone who moves everything to a family member the week after a demand letter triggers almost all of them. And understand where the criminal line actually sits, because it isn't where people assume. Moving assets into a lawful structure is planning. Swearing under oath that you don't own something you control is perjury. Refusing to obey a court's turnover order is contempt, and appellate courts have upheld contempt findings against people who insisted they couldn't reach their own offshore trust. Using any structure to hide income from the tax authorities is evasion. None of those are asset protection. They're crimes wearing its clothes. Real planning is fully reported, fully disclosed the moment disclosure is demanded, and completely boring on paper. So go back to that report, the one that costs less than dinner and arrives before the weekend. It will always exist, and you can't delete it. What you can decide, years in advance, is how many lines come back. Because the settlement value of a case against you was never really about what you're worth. It's about what a stranger can prove you're worth on a Tuesday afternoon before he's ever met you. Buy the insurance first. Build the rest early. Build it honestly. Build it in daylight. And let the question mark do the work that no amount of arguing ever will.